Hi everyone, my name is Abby from Migration Centre of Australia. I'm a registered migration agent here to talk about the Subclass 407 training visa. Now, we know that the training visa requires an organisation to sponsor you, and that sponsorship is called Temporary Activity Sponsorship, which is valid for 5 years. Now, under that sponsorship, you can lodge multiple nomination and visas, right? But that sponsorship will continue. If that sponsorship is about to expire, you can then lodge a new sponsorship beforehand or even after, depending on the circumstances, on how the company plans to use the temporary activity sponsorship. Now, specifically for the 407 training visa, there are 3 streams. The first stream is for registration purposes. The second stream is for enhancing skills, and the third stream is for capacity building overseas. And we'll talk a little bit more about these as we continue on with our presentation today and cover different requirements for each of those eligibility types. Now, there are 3 steps to the process. As I mentioned, there's a sponsorship, nomination, and visa. Right? And the new nomination and visa is required for each candidate that the organisation wishes to train. The Subclass 407 is actually a goodwill visa, allowing Australian companies to sponsor people to travel and stay in Australia for a short period and participate in classroom-based or workplace-based occupational training. We need to ensure that we can demonstrate that the intention of the visa is being met. The intention of the visa is not to provide workers to fill labour shortages. It is simply a goodwill visa designed to help Australia promote its capacity in being able to train overseas workers and enhance their skills for a particular occupation or for their registration type, or to help build capacity for them overseas when they go back to their home country. Now, what are some of the key features about this visa? It allows people to come to Australia to obtain training in different eligibility types, which we'll cover later. It has to be an Australian organisation. Sometimes it can be a foreign government organisation as well. Sponsorship is required to nominate visa applicants to undertake post-occupational training. Occupational training must be provided directly by sponsor in most cases. The visa applicant can be in or outside Australia at the time of application. We just need to make sure that they meet the visa Schedule 1 and Schedule 2 criteria as well. One of the main things to consider here is we need to ensure that they have held a substantive visa within the last 28 days, or they currently hold a substantive visa to be able to apply onshore within Australia. This visa can be for up to 2 years, but we should only nominate the duration that is acceptable as part of that training. So for example, if we can only demonstrate that someone needs training of 12 months to develop their skills, it doesn't mean that we should lodge an application for 24 months. That training plan should be developed according to the requirements of the nominee and their needs. And we'll talk about what the training plan entails later on as well. I've personally trained many migration agents, probably hundreds of migration agents in the training visa. We do specialize in this category, and we also develop training plans across hundreds of occupations, pretty much every single occupation that's on the list. And we have many, I think more than a decade of experience with the training visa itself. So we provide these services to not only professionals within the industry, other migration agents and lawyers, we also provide it to clients that are looking for these kind of specialized services to help cater and meet the requirements of the training visa. Now, what kind of organizations can become approved sponsors? These are partnerships, companies, joint ventures, not-for-profit organizations, incorporated associations and unincorporated associations, or cooperatives. Individuals, sole traders, or sole proprietors are not defined as Australian organisations. Government agencies within and outside Australia can become approved sponsors as well. We just need to make sure that foreign government agencies in Australia are operating in Australia under an official species. Sporting organisations and religious institutions can also become sponsors and utilise the training visa. Now, as part of the sponsorship obligations, it's a requirement for the temporary activity sponsor to ensure they cooperate with inspectors, pay costs incurred in the Commonwealth locating and removing unlawful non-citizens, keep records and provide these as requested by the Minister or their delegate, provide information to the department when certain events occur. So these are changes in circumstances, such as the directorship changing within the company, or if the nominee is not participating in their required training program, or they've resigned, or the company has let you go if you're a visa applicant. These are all changes in circumstances. The company should also secure offer of a reasonable standard of accommodation. This is especially important in cases where the nominee will not be paid, such as in cases of religious institutions. They should ensure that the nominee only participates in the training program that has been approved. If it's outside that, not only will the company be breaching sponsorship obligations, the visa applicant will also be breaching Condition 8102, which we'll talk about soon. The company should also not try to recover any costs associated with the person paying for the training or the recruitment for that training. Now, the sponsorship is valid for 5 years. We've talked about that, and they do not need to lodge another sponsorship for that duration at least. Or they should lodge one maybe 6 months or 3 months prior to make sure that they have a continuing and existing sponsorship if they're looking to continuously sponsor people on the training visa. Now, Condition 8102. This condition restricts visa holders from engaging in work other than work that is related to their approved training program or activity. Even if we talk about an ANZCO occupation, right, it might have 10 tasks within that occupation, but in the training program, we've only covered 6 or 7 of those tasks. That's because they're already deemed skilled in some tasks and unskilled or areas where they need enhancement in other areas according to ANZCO requirements. So that training program has been developed specifically for the needs of the nominee. The nominee should not be doing other tasks. If they are found to be doing other tasks, even if they are related to the occupation, but not in relation to the training program, it can have consequences. And not only for the visa applicant, but as I mentioned, for the organisation as well, as they will be in breach of one of their sponsorship obligations. Now, if the visa holder decides to change organisation and that same training will be organised by a different approved sponsor, then they only need to lodge a new visa application. So, for example, if it's an 18-month training program that has been approved for a software engineer or a chef, as an example. Now, they've completed 6 months with that initial organisation. What happens? They will be required to find a new sponsor, a company that can, or an organisation that can either become a sponsor or already have a sponsorship, and then lodge a visa. Once that visa has been approved, they can commence working for that new sponsor and achieve that training that's still pending. So if they've already completed 6 months, let's say 6 months has been completed, they find a new sponsor, the company is willing to provide the rest of the training. It takes 3 months for the new visa to be approved. That means 9 months have passed on their original visa. That's why we need to lodge a new visa, and that new visa will be lodged for the remainder of the duration of the training program that needs to be carried out. So that will be a total of 12 months. And that's for the example that I used just now, but it varies from scenario to scenario. Now, if you're looking to change sponsors, again, same requirement. As long as the training program will remain the same, you only need to lodge the new visa if they already have a temporary activity sponsorship approval. If they're looking to change or alter the activity or training program itself, whether it's with the existing employer or sponsor or a new sponsor, you would be required to lodge a new nomination and a new visa as well. Now, if the company, for example, is being bought out by another organization, but all the personnel that will be providing the training and the training program itself remains the same, then it may be the case that a new nomination and visa is not required. In cases where we lodge a sponsorship and a nomination and visa possibly on the same day because the company doesn't already have a sponsorship approval. So applications can be lodged on the same day, but they have to be in that order: sponsorship, nomination, and then visa. If the nomination application has been lodged by the organization before the sponsorship application has been approved, then the nomination will not be decided until the approval of the sponsorship. And it's an important thing to note, if the sponsorship has been refused, any nomination application made prior to that sponsorship decision must be withdrawn. Then the nomination application is considered as not being lodged, and the nomination fees will automatically be refunded by the department without request from the applicant. Now, this is especially important in cases where the applicant is on a bridging visa. For example, if the sponsorship gets refused, the nomination will automatically be withdrawn. Therefore, the visa will need to be withdrawn as well, as there's no associated nomination application. That means the bridging visa will eventually end and there will be no review rights available for the applicant to appeal the decision of the department. In cases where there's the sponsorship is approved, but the nomination is refused for some reason, as long as the basic eligibility criteria is being met, and the visa has been refused because that nomination has not been refused, you can actually appeal the nomination decision and the visa decision in most cases. And that means you will still have a bridging visa if you do appeal the decision for the visa itself. Now, let's talk about the different eligibility types. The first one that we talk about is the registration, membership, or licensing, and if it's required for any occupation, whether it's in your home country or in Australia. As long as you can obtain training or practical training, workplace-based training in Australia to meet the registration, membership, or licensing requirements for Australian occupations or overseas occupations, then you can carry out this training in Australia as long as it is acceptable by that registration body. Now, this must be workplace-based training. It should only be for the duration that is necessary for you to obtain your registration, membership, or licensing. You should also have the appropriate qualifications and experience required to obtain the registration, membership, or licensing already to meet that criteria to obtain workplace-based training. You may also require evidence that demonstrates that from your regulatory body in Australia or overseas, and need to demonstrate that you will meet those requirements by obtaining, for example, 6 months or 12 months of training. For example, it could be a Queensland Law Society or one of the law societies across different states in Australia for solicitors that say you need 6 months to obtain registration. Or it could be, for example, pharmacists. They are covered under APRA, or any health practitioners or related occupations required under APRA, which is the Australian Health Practitioner Regulatory Agency. You would need provisional registration to get that training because you're dealing with people's lives when you're practicing in the health industry. So as long as you have that provisional registration for one of those health practitioners, you can also obtain training. Pharmacist is a good example of this, which require, I think, off the top of my head, 1,800 hours of training. They can obtain this on the training visa. The second stream, which is the more important stream and I think used more widely by the industry, is for occupational training to enhance the skills in a particular occupation. Whereas the first stream for registration, membership, or licensing does not define particular occupations, it can be anything. Now, under the eligibility type 2, workplace-based training to enhance skills, you must demonstrate that you are picking one of the occupations that is listed as approved for the 407 training visa. There are hundreds of occupations under this. You must also demonstrate that you have at least 12 months of experience in the last 24 months, full-time equivalent, to be nominated in your occupation. What this means is that by obtaining this training, you are actually enhancing already existing skills and not just trying to achieve basic skills in that occupation. One of the key points to note here is you need a specific training plan that is related to you and specifically you only. It should not just be an off-the-shelf product and you just copy and paste stuff. When we develop training plans, as an example, let's say you have a cook from overseas that is experienced with maybe Asian cuisine, but not experienced with Western or Mexican or Japanese, some other kind of cuisine, depending on what their previous experience is. Then they can come to Australia, be sponsored under a training visa by an organization that has expertise in that specific cuisine to develop or enhance their skills within that industry in a different cuisine type. That's just one example. And obviously there's professional organizations. For example, you'll have engineers that have experience in specific type of civil structures, but require training in different types of civil structures. That's just one example. Then there can be electrical engineers, they can be software engineers, there can be, as I mentioned, health-related industries as well that can come to Australia to enhance their skills, and the list goes on and on. We also need to make sure that the company has the ability, or someone at the company has the ability, to provide that training, or they can hire someone or outsource that person that will be providing that training or part of that training to come in and facilitate it for the specific training needs that are being proposed for the nominee. Now, in terms of that requirement that you need to have 12 months full-time equivalent experience in the last 24 months to be eligible under this enhancing skill stream, that can be employment and or study experience. What does that mean? You could just have employment experience, which is the practical experience, for 12 months in the last 24 months, full-time. And then you could continue that enhancement of your skills in Australia. Or alternatively, for example, you could have just the qualification and then come to Australia to enhance those skills. Or already be in Australia if you've completed your qualification here and apply for the training visa to enhance those skills. The other thing is you could have a combination of the two. You could have a study component and practical experience. So for example, if you've studied for 9 months and have a practical component experience of 3 or 4 months, in total you have 12 to 13 months of experience in the last 24 months, then you would become eligible to apply for the training visa just in terms of meeting the 12 months experience in the last 24 months requirement. Now, the third eligibility type is capacity building overseas, and this actually has 3 substreams. The first one is overseas qualification, where you would come to Australia to obtain or complete a part of a qualification, which would result in you going back and completing that qualification or achieving that qualification, kind of like an exchange program. The second thing is government support. So if you're supported by the government at the Commonwealth, state or territory levels, either in Australia or in your home country. The last one is professional development. Now, this is specifically for people in managerial or professional positions in relation to an overseas employer. You can come to Australia to enhance your skills as a professional in more than likely a face-to-face teaching or classroom-like environment, where you may exchange ideas and develop your skills, and then use that knowledge that you've obtained in Australia to help your overseas employer in your occupational capacity or professional capacity. Now, there are various types of nomination assessment criteria. One of them is that it should be a genuine training opportunity. You should not be trying to utilize overseas workers as to fill skilled labor shortages. It needs to be that you are genuinely providing this out of the goodness of your hearts, and the company wants to invest or operate out of the goodwill to enhance the skills of overseas workers in a particular field or occupation, and then they can take those skills back to their home country. It should also not negatively affect training opportunities for Australian citizens or permanent residents. So in other cases, you may need to demonstrate that similar opportunities have been provided to Australians where they've been allowed to upskill or train themselves in the organisation. It could be in different aspects of the training, or different occupations, but they have been allowed to gain the opportunity to get training, right? It should not be the case where Australians or permanent residents are not being provided any opportunities, but international candidates are being provided the opportunity to upskill or enhance their skills. The other thing is that it requires functional English. Now, functional English is a mandatory requirement that needs to be met to be eligible for the 407 training visa. As I mentioned, we've developed hundreds of, maybe thousands of training plans across the term that I've been working with the company, pretty much in any occupation and industry, and it needs to be specifically addressed for the nominee. We need to analyze the training needs for the nominee. There's a skill audit that should be done, which identifies the skill gaps, and using those skill gaps, the training plan should be developed. And when it's developed, it's specifically tailored to the nominee. As part of the requirements, you must be working at least 30 hours per week, and 70% of that can be practical, or 100% of that can be practical, and up to 30% can be conducted as a classroom-like environment. So you're getting a little bit of that theory component and a lot of that practical component, or 100% practical component, which is, I guess, what is more widely used, because everyone has the ability to learn theoretical knowledges overseas and in Australia, but a lot of people still need that practical component after they complete that qualification. Now, you must be over 18 as part of the visa requirements, have that functional English as I mentioned. You must only nominate in your approved training program and not breach that condition. You must maintain health insurance on this visa. You must meet the genuine temporary entrant criteria, which also needs to be satisfied for this visa. And if you're not getting paid at all, you must provide the ability that you're able to financially support yourself for the duration of your stay within the country. And you should not be paying for obtaining this training. Again, if you are paying for obtaining this training to the organization, or the sponsor organization has recovered costs from the visa applicant to provide this training, you would be in breach of the regulations and the legal requirements, and the government can take action against the organization itself. Now, there's different types of criteria to be met. We won't get too much into it, but Schedule 4 criteria, which covers things like the character, security, debts, unaccompanied minors, unlawful non-citizens, and what can happen there. So make sure when we do visa assessments, we need to make sure that you meet all of these Schedule 4 requirements. We need to make sure you also meet Schedule 5 requirements, which is the special return criteria. Once the visa is granted, it can be granted for example, for the main applicant, but if you include family members, it may not be granted. So what we call it here is it does not have the one fail, all fail criteria. So it could be you as the primary applicant are granted the visa, but your family members or children are not granted the visa. Now, you can be in or outside Australia, as I explained. The visa can be granted for a maximum duration of 2 years. You do have the opportunity to apply again for the visa, but you need to make sure that you can justify why you need further training. Why was 2 years not enough? Why is it that maybe part of that training was not completed in the proposed time frame? There can be multiple reasons for this. You must also make sure you meet Schedule 8 criteria. One of the conditions that we covered as part of the Schedule 8 is the 8102, which is quite important. You must also maintain health insurance. And secondary applicants, this is important to note. One of the key things is that secondary applicants are only allowed to work in the approved number of hours. So that is generally 40 hours per fortnight. And they must also maintain health insurance. Now, volunteer work is also allowed on the training visa, other than the training program that's been approved. But you need to make sure that you can demonstrate that it will not interfere with your occupational training, and it is of benefit to the community, and it would not otherwise be undertaken in return for wages by an Australian resident. So it should genuinely be voluntary work. As I mentioned, there's no limit to the number of visas you can lodge, but you just need to be careful if you're lodging another one that you comply with all the visa conditions and you're able to strongly justify why you need further training. Now, the cost of the visas varies from year to year, but it's required that the company lodges a sponsorship and a nomination, and then the visa application. There are additional visa application charges if you want to include your family members. That applies to applicants over 18 and under 18, as long as they're part of the same family unit. If you have any questions, you can contact us. At the moment, the processing times are quite quick, as of September 2023, and you can generally expect a decision to be made in approximately 2 months, and you will know whether you are granted the visa or not. Again, you can contact us by reaching out to us on 02 4626 1002. Leave a comment below. Alternatively, book a consultation by heading to our website www.migrationcenterofaustralia.com.au.